let's understand international data transfer. What happens? What is international data transfer? What does the topic mean? It means when your data is being transferred outside the European Union or outside the European Economic Area. That is international data transfers. You cannot stop transfer of data outside Europe, right? In this world where you have multinational companies, you would need to transfer some data outside the European Union to get the businesses to function. So it is very important. The GDPR says that if data is being transferred outside, it should be protected as well as it is being protected within Europe as per the GDPR. So the other countries either need to have something as good as the GDPR or find mechanisms around it. The idea of law is never to stop business transactions, right? But we find ways around the real regulations, find certain exceptions, certain measures, which allows us to facilitate businesses with that law, with those legal provisions that are available. So that's what we're going to see, what happens when it is international data transfers. So let's look at this slide first. The EU data protection rules apply. We know, we've reiterated it 100 times in this course, that it applies to, European Economic Area and the EU countries and non-EU countries like Iceland, Liechtenstein, and Norway. And when personal data is transferred outside EU or EEA, special safeguards are necessary. Those special safeguards ensure that data is protected as good as it is within the European Union. And there are specific provisions that govern these cross-border data flow, right? So let me rephrase it, that when data transfers outside the European Union, you have specific legal provisions which help you protect the data or guard it in a way as the GDPR guards it, and that facilitates international trade negotiation. That is how the data is transferred outside the European Union. So transferring personal data outside the European Union requires appropriate basis of transfer and compliance with other requirements imposed by the regulation. So what are these appropriate basis of transfer? That's what we're going to cover next, right? But first we'll talk about why this but I'll also briefly tell you about the appropriate basis. There are 3 appropriate bases that are generally used. One is the adequate decisions. Second is standard contractual clauses and binding corporate rules or, right? You can either use SCC or you can use BCC. BCC is used in certain cases. We will discuss about that. And the third is derogations. Derogations are exceptions. So let's see why this, why do we have such measures around international data transfer? Why can't it just go freely? So the key goal here is to protect data and have a common data protection legislation. There is an academic debate around it, this whole GDPR and international data transfer, that the European Union is trying neocolonialism. That is, they're trying to colonize the world through laws. That is neocolonialism, new form of colonialism. So this is an academic debate, and it has been going on for a while, that when the European Union says that you need to have anything as good as the GDPR, then it means you're trying to states to comply with your regulations as they were doing, 200 years, 300 years back. So this is also a form of neocolonialism, but the bright side to this is that GDPR is a very good law. It's the most extensive form of law that's protecting personal data. So in this case, what happens is that it is good to implement GDPR. It is also good because many countries who do not have the financial strength to set up a law commission and discuss around what kind of personal data laws should be there and have research around it, invest that much, can just adopt GDPR into their framework and get an adequate country membership from EU after various verifications and discussion, and it becomes easier for them. So they have a ready-made law also to copy. But then that's the very contention, that ready-made law, which it is also a form of colonialism. There are many pros and cons to it. There are many debates around it, but just a food for thought. When you're reading these new laws, if you want to do something academically, maybe in GDPR, then something just to think about if you're planning to have a master's degree or writing a thesis in this. So this can be an interesting topic, that whether GDPR is a form of neo-colonialism. Just a food for thought. Don't dwell more into it. We are more into practical matters. So I've taken Finnish examples, couple of places, because I am in Finland and I'm more aware of things that are happening in Finland. So one of the key goals of the common data protection legislation is to ensure free flow of personal data within the European Union, and that happens with the help of GDPR and data processing agreement. Thus, the same rule applies to transfer of personal data to EEA member states. Right, EEA is that we saw the European economy. So what the idea is, free flow of data. The level of data protection guaranteed for personal data by GDPR can decrease when data is transferred outside European Union or outside the European Economic Area. That is what they believe. And the belief is also correct because not all countries have a data protection law in place. Given us, India doesn't have a data protection law in place. China has a very weird kind of law in place where a government has quite a lot of right to see personal data. US has certain laws which allow the US government to ask for data even if it belongs to people outside the European Union. So the same amount of protection which the GDPR guarantees, it's not guaranteed outside the European Union or the European Economic Area. And that is why more stringent measures are taken to ensure that the GDPR level of protection is given. The European Union believes that when data is transferred to countries outside the European Union, there are more risks to data subject because it is their data that is being processed. So obviously there is more risk to data. Therefore, the GDPR provides conditions applied to the basis of transferring personal data out of European Union to a third country or international organizations wherever the data is being processed.